Discharge of contract. Friends, when a contract is entered into by the parties, it gives rise to certain rights and obligations out of such contract. Now, these rights and obligations will remain valid until the contract is discharged. For example, you enter into a contract with a person, but later some dispute arises between two of you, and both of you refuse to perform your part of contract and simply sit at home. After 6 months, the other party suddenly wakes up and sue you in the court for the non-performance of the contract. Now you thought since the other party is not performing the contract, even I don't need to perform it and I can simply sit at home. Well friends, it doesn't work that way. As I said before, the rights and obligations under the contract will continue until the contract is discharged. Since the contract was not discharged between you and the another person, the contract was still valid and the other person still has the right to sue you in the court of law. So friends, discharge of contract means extinguishing the rights and obligations arising out of a contract. Now, how can you be discharged from a contract? There are several ways to do that. Let's discuss these one by one. The first way to get discharged from the contract is by performing the contract. Simple. You perform the contract and then you'll be discharged. But note that only the party who performs its part of contract will be discharged. If one party performs a contract and the other doesn't, then the party who hasn't performed the contract will not be discharged. The other party can still sue such non-performing party for breach of contract. Now, sometimes one party is ready and willing to perform its part of a contract, but the other party is not accepting such performance. This is called attempted performance or valid tender. For example, A agrees to paint B's house for 5,000 rupees. A and B both enter into a contract. Later, B says that he doesn't want his house to get painted. Here, Mr. A is ready and willing to paint the house, but he could not because B is not letting him paint his house. So in such a case, it will be deemed that A has performed his part of contract and will be discharged from the contract. However, B will not be discharged from the contract and can be sued by A for breach of contract. Okay. Second way to get discharged from the contract is through mutual consent or agreement. Friends, just like a contract is created by agreement between parties, the same way a contract can also be discharged by the mutual agreement of the parties. Now, there are 4 types of agreements that will result in discharge of contracts. These are novation, alteration, rescission, and remission. These are covered by section 62 and 63. And there is one more such contract: novation, alteration, rescission, remission, and waiver. So let's discuss these one by one. Novation means when the existing contract is replaced by a new contract. When a contract is novated, the existing contract is discharged and a new contract comes into existence in its place. The consideration for the new contract is the discharge of the old contract. The new contract may be between the same parties or different parties. Take an example. There is an existing contract between A and B wherein B gives a loan of 5 lakh rupees to A at 10% interest and A agrees to repay the loan in 1 year. Later, A and B again entered into a contract where A agreed to transfer the ownership of his car in the name of B on the condition that the loan B gave to A is waived. This is called novation between the parties. Here the existing contract is replaced with a new one. Existing contract of loan stands discharged and a new contract of transferring ownership of the car comes into existence. Similarly, there can be novation involving new parties. For example, if B agrees to waive of the loan if A transfers the ownership of his car to his brother C. Now here there is a change of parties. The new contract will be between A and C and the old contract between A and B stands discharged. Now friends, can you tell me what is the consideration under the new contract? The consideration for transfer of ownership of car if the discharge of the old contract, that is waiving of the loan. Clear? It is important to note that a contract can be novated only with the consent of both the parties. If any one of the parties do not agree to novation, it cannot take effect. Also, the new contract must have all the essential elements of section 10 of the contract. Now, the second type of agreement which discharges the parties from the contract is alteration. Friends, alteration means to modify or change. So when a material term of the contract is modified or changed, it is called alteration of the contract. Now, what is material change? Material change is something which changes the rights and obligations of the parties under the contract. For example, if B gives a loan of 1 lakh rupees to A at 10% rate of interest per annum, and later the contract is modified and rate of interest is changed from 10% to 15% per annum. Now here the obligation of A is changed, as he is now required to pay interest at 15% per annum. So this change will be regarded as material change. Non-material change would be something like correcting a spelling mistake or correcting any clerical error in the contract. So a contract is said to have altered only when some material terms and conditions are changed. And what is the impact of alteration on the contract? The impact is that the old contract is discharged and the new contract takes its place. Like in the example above, the 10% contract is discharged and 15% contract takes its place. Here also the contract can be altered only by the mutual consent of all the parties to a contract. Now friends, you must be wondering then what is the difference between novation and alteration? Friends, the difference is that in case of novation, there may be a change of parties under the new contract. However, the alteration takes place between the same parties and only the material change in terms and conditions take place. So that's the only difference between the two. Hope that is clear. Now, next type of agreement that results in discharge of a contract is rescission. Friend, rescission means to cancel. A contract is entered into by the mutual consent of the parties. The same way a contract can be cancelled by mutual consent of the parties. So, if the parties to a contract enter into an agreement to cancel any existing contract between them, then the parties will be discharged from the contract and the contract need not be performed by any of the parties. This is called rescission. And what is the difference between rescission and novation and alteration? Well, in novation and alteration, the existing contract is replaced with a new contract. But in rescission, the contract is simply terminated by mutual consent of all the parties involved. It is also important to remember that an agreement to rescind the contract must be entered into before the date of performance. Otherwise, parties may be held liable for breach of contract. Hope this is clear. Next type of agreement that discharges the parties from the contract is remission. Friends, remission means to reduce. Reduce what? Reduce the performance or obligation of the other party. Remission is covered by section 63 of the Act. According to section 63, promisee may remit the performance of the contract either wholly or partly, and such remission would be valid even if there is no consideration for such remission. Take an example. B gives a loan of 10,000 rupees to A. Later, A pays 5,000 rupees to B as repayment of loan and B accepts it as full and final payment of the loan. So here, B has partly remitted the performance of the contract by accepting 5,000 rupees instead of 10,000 rupees for the full settlement of the loan. Both A and B stand discharged from the original contract. Hope this is clear. Last one is waiver. Waiver means to give up your right. Suppose if B gives a loan of 10,000 rupees to A, later B gives up his claim of 10,000 rupees and relieves A of any liability to pay him, then such contract is also valid. This is called waiver. Both A and B stand discharged from the contract, and B cannot bring a suit of recovery of 10,000 rupees later. Hope this one is clear too. Next one is discharge because of subsequent or supervening impossibility or illegality. Friends, as per section 56, an agreement to do an impossible act is void ab initio. That means such agreements can never be considered as contract. So no question of getting discharged from such contracts. For example, an agreement to make a dead man alive is void ab initio, as it is impossible to make a dead man alive. So if it is very obvious to all the parties that agreement is impossible to perform, then such agreement will never be a contract and there is no need for any discharge. But sometimes impossibility is not obvious and one party may not be aware of the impossibility. In such a case, the party who was aware of such impossibility can be sued by the party who was not aware of such impossibility. For example, A contracts to marry B, but A is already married and B is not aware of A being already married. Here, A is very well aware that he cannot marry again, but B is not. Here, B can sue A for any loss she may have suffered due to non-performance of the contract, even though agreement is void ab initio. Now, another scenario is subsequent impossibility. This means an agreement was perfectly valid when it was made, but subsequently something happens that makes the contract impossible to perform or makes it illegal. In such a case, all the parties are discharged from performing the contract and relieved from their respective obligations under the contract. For example, A agrees to paint B's bungalow for 1 lakh rupees, but before A could paint the house, B's bungalow catches fire and it's completely destroyed. Now it is impossible to paint the bungalow because bungalow is completely destroyed by fire. So both A and B will stand discharged from the contract, and neither A needs to paint B's bungalow and neither nor B needs to pay anything to A. And no one can go to court to claim compensation for non-performance of the contract. This is also called frustration of the contract. We generally get frustrated when we want to do something, but due to some difficulties or hurdles we are not able to do it. So we get frustrated. Same way, when contract which was never expected by parties to become impossible to perform due to some uncertain events, it is called frustration of the contract, because parties are ready and willing to perform the contract, but they cannot perform it due to some events making the performance impossible. This is also called doctrine of supervening impossibility. In order for section 56 to apply, the following points must be noted. First, the act should have become impossible to perform. Second, impossibility should be something which parties cannot prevent. Third, impossibility should not be self-induced or due to negligence of the parties. Right? If these three conditions meet, then section 56 will apply. So if in the example above, if B's bungalow caught fire due to negligence of Mr. B, then contract cannot be discharged and B will be liable to compensate A for the loss of money. Similarly, B had an opportunity to call fire brigade and prevent damage to his bungalow, but he did not do it. Then also B will be liable to pay compensation to A. Clear? Now, let's discuss certain cases where doctrine of supervening impossibility applies. Point number 1, destruction of subject matter. Like the example of bungalow I discussed above, a bungalow was supposed to be painted, but the bungalow itself is destroyed by the fire. So the subject matter of the contract does not exist anymore. Contract will stand discharged because of doctrine of supervening impossibility. Second, failure of purpose for which contract was made. Suppose you enter into an agreement with a photographer to do a wedding photography for an upcoming wedding in your family. However, a few days before the wedding, the girl and boy decide not to marry. Here, the purpose for which the contract was made is defeated and the parties stand discharged. Third, death or personal incapacity of the promisor. Where the contract involves personal skill and the party who was supposed to perform the contract through his personal skill dies or becomes incapacitated due to illness or accident, then the contract will be considered impossible to perform. For example, you contract with a famous painter to draw a painting for you. Before the painter could draw the painting for you, he dies. Or maybe in an accident he loses his right hand from which he used to draw. Now, can anyone else draw this painting on his behalf? No, because the painter had that special skill. He had that special talent and no one else will have that exactly the same skills. So the contract will be discharged due to supervening impossibility. Next is change of law. For example, two parties contract for sale and purchase of polybags. But later, the government brings a law which bans the sale and purchase of the polybags. Here, the contract will stand discharged on the ground of supervening impossibility. Last, outbreak of war. Suppose you contract with a person who is a Pakistani citizen. After the contract, a war breaks out between India and Pakistan. Now, that Pakistani national will become alien enemy for you, and any contract with such alien enemy during the period of war will remain suspended. We have already discussed about this, right? Alright, so I hope this is clear. Now, so far we have discussed about cases which will be covered under the doctrine of supervening impossibility. Now, let's discuss about the cases which cannot be covered under the doctrine of supervening impossibility. First is difficulty in performance. A contract cannot be discharged just because it is difficult to perform. Difficulty is not an excuse. Unless the contract is impossible to perform, it cannot be discharged. Second, commercial impossibility. Friends, commercial impossibility means if the contract cannot be performed without incurring a loss. For example, A contracts to sell onions to B at 60 rupees per kg. After the contract, onion prices soar to 100 rupees per kg. Now A will not be discharged from the contract and he will still have to sell onions to B at the agreed price, which is 60 rupees per kg, even if he has to bear loss due to increased price of onions. Right? So commercial impossibility is also not an excuse. Third, impossibility due to a default of a third person. Again, a party cannot get a discharge from the contract because the third party with whom he was dealing makes a default. For example, A agrees to sell B 100 kgs of dates within 1 month to be imported from Dubai. A planned to procure these dates from an agent in Dubai. The agent in Dubai does not send dates to B to A, and as a result, A could not deliver dates to B on time. Now, A cannot get a discharge from the contract because the agent defaulted. The arrangement between A and the agent in Dubai is a separate thing, and it's up to A how he manages it. But the contract between A and B will still remain valid, and A can be sued by B in the court of law if he does not deliver on time. Right? Clear? Similarly, strikes and lockouts are also not an excuse. And last one is the failure of one of the objects. So if a contract has multiple objects, then failure of just one of the object does not discharge the contract. For example, you contract with a travel agent to manage your trip to Kashmir. Your travel package included air tickets, hotels, Shikara boat ride and other sightseeing. Out of this, Shikara boat ride was cancelled due to bad weather. Now, just because you could not go to Shikara boat ride, you cannot be discharged from the contract with your travel agent because the contract included a lot of other things than just Shikara. So Shikara boat ride cannot be the sole criteria for discharge of the contract. Clear? Another way to get a discharge from the contract is by lapse of time. Friends, Limitation Act prescribes a specific time within which an action for breach of contract should be taken. If no action is taken during this period, then the party loses its right to sue for breach of contract and all the parties are discharged from the contract. So you see it is all time bound. You cannot retain a right to sue a person all your life. If you want to sue, then sue within the prescribed time. Normally, Limitation Act provides for 3 years to take action for breach of contract. But if a contract is required to be performed within a specific period and the party does not perform within that period, then the other party is discharged from the contract and need not do anything under the contract. Clear? Next is discharge by operation of law. These are the situations where law relieves both the parties from performing the contract. First is death of the promisor. Friends, please note that in a normal contract, if the promisor dies, then the contract will still have to be performed by his legal representatives. There is no discharge there. However, in a contract where personal skills of the promisor are required to perform the contract and the promisor dies, then the law relieves both the parties from performing the contract. This is because this type of contract cannot be performed by anyone else. For example, if you want a painting to be drawn by M.F. Hussain, then no one else can draw on M.F. Hussain's behalf. Similarly, if you want Sonu Nigam to sing a song for you in a concert, then only Sonu Nigam can do that because no one else can sing in the same voice. Clear? Second situation is insolvency. If one of the parties become insolvent and the insolvency court passes an order of discharge, relieving the insolvent party from all the liabilities or debts, then the contract stands discharged. Okay. Third is merger. So, when an inferior right contract is merged into superior right contract, then the former contract stands discharged. For example, if a part-time lecturer is made full-time lecturer, the contract of part-time lecturership stands discharged. Clear? Fourth, when a material alteration is made to the contract by one party without the consent of the another, then the whole contract becomes void and parties stand discharged. Simple. Alright, so these were the situations where the law relieves the parties from their respective obligations under the contract and the parties stand discharged. Let's move on to the next and the last way through which a contract can be discharged. Another way that discharges the party from performing the contract is by breach of contract. So friends, if one of the parties to the contract does not perform its part of contract, then the other party or parties also need not perform their part of contract. The aggrieved party can of course sue the non-performing party for breach of the contract, but it also need not perform the contract. For example, A agrees to pay 10 lakh rupees to B for constructing a house for him. If B does not construct the house, A need not pay him. But A can still go to the court and sue B for the breach of contract. B cannot say that if he has not constructed the house, then he did not even take the money. Once you enter into a contract, you are bound by the contract. Now friends, there can be two types of breach. One is anticipatory breach and another one is actual breach. Anticipatory breach means a breach of contract before the time fixed for its performance. For example, you enter into a contract with a singer to perform on New Year's Eve. After the contract, the singer denies to perform. So the time of performance has not yet come. Time of performance is New Year's Eve, but before the time fixed for performance, the singer says he cannot perform. This is an anticipatory breach. Now, anticipatory breach can be of two types. It can be express or it can be implied. Express anticipatory breach means when a contract is breached by words spoken or written. Like in the example above, if the singer calls you on phone or tells you that he will not be able to perform on the said date, then it will be an express breach. Similarly, if the singer writes you an email informing you that he will not be able to perform on the said date, then also it will be an express anticipatory breach of the contract. Now, if the singer takes up some big international contract to perform on the same day in USA, then this automatically means that he will not perform for you on New Year's Eve, as the singer will be traveling to USA for another big contract. This is called implied anticipatory breach of contract, because the act of the singer is enough to show that singer is not going to perform under the contract. Clear? So if there is an anticipatory breach by one party, the other party has two options. First, treat the contract rescinded and sue the other party for breach of contract without waiting until the due date of the performance. Second option is to keep the contract alive and operative until the due date of the performance, giving the other party a chance to perform the contract, and then sue the other party if he does not perform the contract. Clear? Another type of breach of contract is actual breach. Actual breach may also discharge a contract. Actual breach means when a party does not perform the contract on the date fixed for the performance. For example, one of the party who was supposed to deliver goods on 20th March 2020 does not deliver the goods as per the contract. This is an actual breach because the party failed to perform on the due date. So both anticipatory breach and actual breach can discharge the parties to perform the contract, in addition to suing the defaulting party in the court for breach of contract. Clear? Alright friends, so this brings us to the end of the chapter discharge of contracts. I hope this is all clear to you. So see you in the next chapter.